is to remind some of you that our clerk of the Supreme Court is retiring in June, and this is the woman seated to your left in the red. And I wanted to give just a little bit of information. Her first day as the clerk of the Supreme Court was September 1st, 1991. Her first docket was announced September 9th through the 13th of 1991. The number of dockets, as best that we can determine, that she has announced in her career is 762. And the number of cases on those dockets, as best we can determine, is around 3,600. Was anybody here on September 9th, 1991? I take it not. Stan Hazlitt raises his hand. As you know, these proceedings, as they have been since for the last 18 months or so, are broadcast live on the internet, and we have a camera operator who operates several cameras. I don't know whether she has ever been able to catch Carol Green on the camera. So I'm going to totally embarrass Carol Green at this time and ask her to come stand before me for the purpose of my shaking her hand, but the real purpose is so we can get her live on the internet. Ms. Green. Because I want everybody to know what a great employee she has been for us over all these years. If you could take more than 30 minutes for your speech, I appreciate it.
Well, thank you, Chief Justice Madison, members of the court. It certainly has been my pleasure to announce these many good dockets. I'm frankly amazed at the number. I've never counted. But thank you. I appreciate it, and now I expect that you intend that I will call yet one more.
Well, you've only done it 762 times. I think you're capable. Would you please do the honor of calling this morning's docket? Thank you.
Appeal number 106,894, State of Kansas versus L. Brown, Sedgwick County, brief both sides.
May it please the court, Joanna Lavastida of the Appellate Defender Office for the appellant, Lopez Brown, present ready for argument.
May it please the court, Assistant District Attorney Boyd K. issued on behalf of the state of Kansas, present ready for argument.
Appeal number 108,218, State of Kansas versus Kevin L. Brown Jr., Sedgwick County, brief both sides.
May it please the court, Michael Whalen on behalf of the appellant Kevin Brown, ready to proceed.
Appeal number 108,500.
Ms. Green? I know you're flustered by all the attention.
May it please the court, Assistant District Attorney Matt Maloney, ready for argument.
Mr. Maloney, I apologize.
Not necessary.
I think I did that actually, Chief, on the first docket I had.
Kind of like bookends, is that it? You start and end that way.
Appeal number 108,586, State of Kansas versus Williams, Sedgwick County, brief both sides.
And Stephen J. House on behalf of Kiara and Williams, I'm ready to proceed.
May it please the court, Assistant District Attorney Leslie Isherwood, appearing on behalf of the state of Kansas, present ready for argument.
Appeal number 105,695, State of Kansas versus Julian, on petition for review, Rice County, brief both sides.
The state appears by Assistant Attorney Natalie Chalmers and is ready for argument.
May it please the court, the appellee, Alan Julian, appears and through counsel Greg Bell. I am prepared for it.
Appeal number 109,836 and 111,126 in the matter of Miriam McMaster, original action. There are no briefs in this matter.
May it please the court, Stan Hazlitt, appearing for the disciplinary administrator's office, ready to proceed, and honored to be here today, Ms. Green.
May it please the court, the respondent appears in person by John Ambrosio. We're ready for argument. Good luck, Carol.
That concludes the docket, Your Honor.
Thank you, Ms. Green. One quick note before we start. Ms. Green is leaving our employment voluntarily. All right. We'll get down to serious business. I'll now call the first case on this morning's docket. That is case 106894, State of Kansas v. Cortez Brown.
May it please the Court, Joanna Labastida of the Kansas Appellate Defender Office for the appellant Cortez Brown. If I may, Your Honor, I'd like to request 3 minutes rebuttal.
3 minutes is granted.
Thank you. And unless the Court has other plans, I'd like to focus on the first issue and potentially submit the remaining issues on the brief if there aren't any other questions. The first issue raised in the brief was that the District Court erred in granting a withdrawal of Mr. Brown's motion for new counsel without sufficient inquiry. I know you're familiar with the facts, but just to remind you, Mr. Brown filed a pro se motion for reappointment of counsel, complaining of conflict with his attorney. And that motion was set for a hearing, and at some point, the motion was withdrawn.
Do you have any understanding of how that happened?
I have no idea. At sentencing, when Mr. Brown brought up that motion again, his attorney at the time had no knowledge of the motion. Mr. Brown, I don't suspect, would have been allowed to withdraw it, but calling the court itself, I'm not really sure how that got withdrawn. But the problem is that there was no inquiry.
Did he have Mr. Mank as his attorney at the time he filed his pro se motion?
Yes, he did.
Okay.
He specifically mentioned Mr. Mank in the motion, that there was a breakdown in communication, et cetera, et cetera. So.
Would you agree that from that point of the withdrawal to the sentencing hearing, there were multiple occasions on which Mr. Brown would have had the opportunity to ask the court about that motion?
I would agree with that. Mr. Brown's discussion with the court at sentencing, he was informed by Mr. Mank that the court had withdrawn the motion. I'm not sure what communication happened between Mr. Mank and Mr. Brown, but I would suspect that maybe Mr. Brown didn't feel like he could bring it up again.
Well, that kind of comes to my next question, which is, do we just have to suspect what happened? Is there any development in the record at all that would tell us what his thought process was, or
what Mr. Brown's
why he did not take any steps? Or
I didn't see anything in my quick review of the transcript again, preparing for argument, as to why he didn't bring it up again. I'm not sure. I don't think that inhibits this court from remanding for further inquiry or remanding to the district court to inquire as to the conflict.
Except it is a point of distinction in some of our case law. And we do have some cases where this court's made that point and has determined that it basically had been the motion had been waived because of the defendant's failure to renew the motion in a timely fashion through the process.
That's true. The Van case that I cited in my brief, he did bring that up several times throughout the process. I do think that the facts in this case are peculiar, in that someone somewhere along the lines withdrew the motion, and I'm not sure when I think Mr. Brown found out about it like the day the hearing was set, and was told that the district court withdrew it. So I'm not sure if he felt he could bring it up again. So that would have to be something that would be fleshed out below.
But we don't even know that. They could have had a full hearing, as far as we know, because all we have is that one record sheet that just says motion withdrawn. I mean, they could have brought everybody into a courtroom, and he could have voluntarily waived it, and we just don't know, do we?
Well,
and I think that's a big problem.
The journal entry indicates that there was no hearing. It wasn't signed by either attorney. It's page volume 1, I believe.
That's a handwritten minute sheet where
right.
they checked the box, said withdrawn.
Mm-hmm. It was, yes, Your Honor.
I wanted to clarify because journal entry sometimes implies something more than a sheet of paper with a check mark on it.
That's true. But I believe when I was writing the brief way back when, I looked into whether or not there was a hearing, and there wasn't a record of that. So unfortunately, we just don't know what could have happened. The state, in its brief, kind of characterizes this motion as a motion for new trial. That's not how it was raised below. That's not how I raised it in my brief. He was basically complaining that the district court never took that motion, pro se motion for new counsel seriously.
When did Mr. Mank become aware of the pro se motion?
Well,
did he know about it at the time it was withdrawn? Or it appears at the sentencing, he kind of says, this is all news to me.
That's right. I mean, those are his statements at sentencing.
So is that accurate? Did he not know about any of this until sentencing, or did he know about his client's desire to have him withdraw at the time he was seeking it?
Mr. Cortez's statements at the sentencing hearing indicate that he did discuss it with Mr. Mank before
right, that's what it,
trial.
Okay.
And his attorney maintained that he had no knowledge of that. Although you could kind of construe his comments as to he has no knowledge of the withdrawal of the motion. So I suppose that's something else that would need to be discussed in remand. Anyway, as I was saying, I never characterized this as a motion for new trial based on ineffective assistance of counsel. It was more the district court's failure to inquire into any kind of conflict between the attorney and even actually at sentencing, he doesn't inquire fully into that conflict. He basically chastises the defendant into the abilities of his attorney and whatnot. So
what is the remedy?
I believe State v. Van offers some guidance on that. In fact, one of the last paragraphs discussing that issue says that it would be remand for determination as to whether the defendant can establish that a conflict of interest adversely affected his counsel's performance. And I think that would be an appropriate remedy.
So that's basically what the district court was saying, is counsel did a great job, and so there was no prejudice to you. But you're saying that he's entitled to a hearing at which he can present evidence in that regard?
Yes, Your Honor. And hopefully he would be appointed a new attorney to help him with that hearing so that Mr. Mank could be a witness at that hearing. I do understand that the facts of this case, this particular issue, are very peculiar because it appears that there was a withdrawal of that motion, but Mr. Brown and Mr. Mank both deny that they did that. So if neither one of them did that, who did? That would have to be something that would be discussed as well.
Who bears the burden for the silence in the record in this case?
Well, it's typically the appellant who's, I suppose it's anyone who wants to raise an issue should designate a record on appeal. I attempted to. There's nothing in the record, so I'm not really sure at this point what could be done with that. There's literally nothing in the record that would help figure this out.
Who bears the burden once a motion is filed to bring it to hearing?
Well, the district court has the burden to inquire into the conflict.
I'm talking more generically. When the pro se motion is filed, it needs a hearing.
Right.
And is that the court's responsibility, the defense counsel's responsibility? Whose responsibility is it to get that to hearing?
I'm not positive, but I think it would be the defendant's responsibility, defense counsel, in conjunction with the court, of course. The problem in this case is that Mr. Brown had no knowledge of that withdrawal until basically it was too late, and Mr. Mank assures the court that he did not withdraw that motion either. So,
excuse me, I thought you said that he learned of the withdrawal on the date of the hearing, the original date of the hearing.
Right. He thought he was going to that hearing at some point, and it never came about.
That's what I thought the background was. So that's not too late. Could have renewed it right then.
That's true, except that he was told that the district court had withdrawn it, so.
Misinformation.
And what would that look like, a renewal?
Potentially at trial or sometime during the trial, but I can't say what.
No, I mean, if the court withdraws a motion, does he have to file another written motion? Because, I mean, there's certain rules about filing motions.
Mm-hmm.
At the very least, he'd have to file a motion for reconsideration, wouldn't he?
That's true, although I suppose a pro se defendant might be intimidated by the fact that he heard the district court had withdrawn the motion itself. So I'm not really sure, what in his mind, what he thought he could do.
Actually, I'm trying to help you here
Sure.
as to how he could renew that motion on that day.
Mm-hmm. And he could have, definitely.
Counsel,
Yes.
I'm a little confused. What was the hearing, the specific hearing you were referring to when you said he got to the hearing and learned that the motion had been withdrawn?
Right. The hearing was on the pro se motion for new appointment of counsel. He, at sentencing, said that he thought that day he was going to a hearing, but they never came to get him from the jail. And so at some point, Mr. Mink told him that the district court had withdrawn the motion. It's all very confusing because it doesn't make sense. As attorneys, we know that that's not typically how it goes, but that was what Mr. Brown's understanding of the events were.
Okay, well, there's a minute sheet, I think it's called, signed by, I believe it's Judge Wilbert, for the January 21st, 2011 pro se motion for reappointment of counsel hearing. Mm-hmm. And it does indicate who the says plaintiff's attorney and defendant's attorney are. I'm a little confused yet. Is that the hearing you say that your client attended and learned it had been withdrawn?
No.
Or are you talking about the sentencing hearing?
He indicated at the sentencing hearing that back in January, when he thought that this was set for a motion, he was never brought to court for that motion. And that journal entry indicates that there was no record taken. And I can double check while the state is arguing whether or not the parent's docket shows that there was a hearing, but I don't believe there was. Otherwise, I would have requested that.
Actually, the line record taken by is blank. The line for the plaintiff's attorney to approve is blank. The line for the defendant's attorney to approve is blank.
That's right. And in past, those written journal entries, they'll have both attorneys' names at the top just to show who represents each side, but not necessarily who was present at the hearing. So I raised several issues in this brief, and I'm prepared to answer questions on any of those. But other than that, I conclude my comments.
Any further questions of counsel?
Yes, I do. I'm looking at this minute sheet. I hadn't looked at it that closely before, and I see up there it says date January 21st, 2011, and then the date the motion. Okay, the motion was December 29th, and then the order was January 21st. Never mind. I see. Okay.
Thank you.
Any further questions? Thank you.
All right, thank you.
May it please the court, Assistant District Attorney Boyd Ishuat on behalf of the state of Kansas. And sorry if it seems like I'm yelling, it seems louder than normal. But the first thing I'd like to attempt, I guess, to clean up to some extent is the comment that Mr. Mank makes at sentencing, to my knowledge and recollection, of course the record will correct me if I'm wrong, but the comment was, "This is news to me." And I've even, I was going to say,
news? What was
that? That's what I'm saying. I think that if you put it in context, I think "this is news to me" is his complaint, his renewed complaint that something was wrong. That's news to me, because we've gone through this entire trial and he's not complained. Sure, he complained before, and I'm not suggesting the record states this, I'm just surmising from the statement. he complained before we got together, that motion was withdrawn, and now he waits until sentencing to complain again. This is news that it's news to me that he's unhappy. We solved that riddle, and now if he wants to complain again, this is news to me. That's how I took it, but again, I have nothing to cite to that buttresses that suspicion.
Counsel, is it possible he's saying this whole issue is news to me? I'm unaware of a pro se motion to reappoint counsel. I know nothing about this alleged withdrawal of the motion. Is that a possibility?
I suppose it's possible, but I would suggest that my take is more possible only because the minute sheet indicates that Mr. Mank, I assume was present or consulted, or I'm not sure what to make of the minute sheet.
Do you dispute that defendant did not appear in court?
I would assume that the minute sheet would reflect that. I have no independent knowledge of an actual hearing that took place, and of course we'll never have any indication that Mr. Mank met with his client and what they discussed, because that's a privileged matter.
Well, do either the defense counsel or the district court possess the authority to withdraw Mr. Brown's pro se motion without him being present?
Well, I don't know, the defense counsel I guess could if they've had a conversation and everyone was on board with it as an officer of the court.
You really believe that? How does that dispose of the district court's inquiry to make the district court's duty to make an inquiry on a pro se motion?
Well, I guess the short answer for me on this case is if counsel is complaining about, I guess, and it was never really clear to me in the brief, but if counsel is complaining about the duty to inquire, then that duty was, to me it's interesting that filing the motion can trigger the duty, but withdrawing the motion can't exhaust the duty. It's to me, if you're going to complain about the lack of an inquiry, that first complaint was lodged at sentencing more than 14 days after the verdict, and counsel indicates that she's never argued that she's only ever argued that she wants the inquiry. Her brief asks for relief in the form of a new trial. So she's not asking for a hearing on the conflict. She was asking for relief. So that's why I'm confused. If the complaint is that there was no inquiry, one, the motion was withdrawn. Two, the first time we hear about the complaint of no inquiry was 14 days plus after the verdict, which, as we indicate in our 609 letter on Holt.
Why does there have to be a renewal of the motion for us to go back to consider if there was error in the pretrial, at the handling of a pretrial motion?
I would assume because I've never been a district court judge, but if a motion is withdrawn, I assume that there isn't a district court judge in this state that resolves the merits of motions that have been withdrawn.
I would give you that on any situation except where there's a pro se request for new counsel, because I think our case law is pretty clear that then the district court has a duty to inquire of the defendant, not of defense counsel.
And those statements are made not in cases where they've been withdrawn.
But the defendant, there's nothing to tell us the defendant withdrew his motion, is there?
There is nothing to tell us that the defendant didn't.
And so how can we resolve this without at least remanding for a determination of that fact?
Well, again, that's not the request that's not the relief that's been requested. It's pretty clear the relief that's been requested is a new trial.
I thought she made the request this morning to remand it for a hearing.
Well, she may have, but I'm looking at page 6 of the brief, and it says this court must reverse.
Well, I understand what the brief says, but...
Okay. Well, if the target's changed for the first time from the podium, then again...
The target hadn't changed on the error.
I'm sorry?
The target hasn't changed on the error, whether there was error. And would you agree there was error if the defense counsel or the court, sui sponte, withdrew the motion without the consent or without making inquiry from the defendant. Would you agree that's
without the
error?
consent? Without the consent, sure.
Or without making inquiry, if the court's put on notice of the possibility of a conflict, which can happen short of having a motion. And so you would have to have, at the very least, consent and probably have a inquiry. Wouldn't you agree?
Yes, but my point on that is the first time in this case that we hear that there's a complaint about the withdrawal of the motion is 14 days plus after the verdict.
But I don't understand, again, I don't understand why there had to be a renewal of a motion for us to be able to look at an error that occurred in handling a motion and at a...
Because you're presuming there was an error. The motion was withdrawn. We don't know if there was error in the withdrawal of the motion. That's counsel's responsibility as the appellant to designate a record. If counsel wants to make a claim that my client's constitutional rights have been violated based on something that happened here, and counsel finds that, well, the something that happened here isn't clear, they don't get to just steamroll forward and ask you to guess about what happened.
It is clear that there's no record of an inquiry. Isn't that all we really need to know?
It's clear in this record, it's clear from the record on appeal as it sits today that there's no inquiry, but we don't know what happened.
Are you suggesting there's something to be found that appellate counsel for defendant has not found?
Yes, it could be. I'm suggesting that they could have requested that this be temporarily remanded to the district court to determine what happened.
I understand that. She's basically asked for that today. So putting that aside for a second, are you saying there's something in the record other than that minutes sheet?
I can't point to anything in the record other than
or
the
something
suspicion
that
of
exists
what,
outside the record. You don't know of it. All we have is a minutes sheet with one mark on it.
That's correct, and I have no absolute knowledge that there was or wasn't, one, a hearing,
right.
Two, some
wrong.
sort of discussion between counsel and her client. That would be privileged. We'd never know.
Well, obviously, if it goes back for hearing, that you could know from counsel.
Absolutely.
Because then the privilege is
absolutely. It's just
for purposes of finding out what happened.
It's just I suppose I've made myself clear, and the court just isn't willing to go with me. But my point is that the first time anybody complains about the goings on with the withdrawal happened at a time that I'm suggesting on your cases indicate that the district court didn't have jurisdiction to resolve it. Therefore, this court doesn't have jurisdiction to resolve it. I totally get that we can always remand everything and get a better picture about what's happened. The point is, if this court is without jurisdiction to do that, how are you going to do it? There's nothing wrong with letting this process work and having this gentleman file a 1507 where the same thing could happen, and it would happen in alignment with this court's rulings. It's always clear that even in a case where you don't have jurisdiction, if you remanded it down for a hearing, we might get a better picture.
Yeah, I think that I would agree with you that one choice is to go down the 1507 path. But another choice might be looking at this pretrial error. And I think we have jurisdiction to look at whether there was a pretrial error. The defendant has raised, said she, but the defendant has raised an issue about the duty to inquire as well as the procedure that was used to withdraw this pretrial motion. I think we have jurisdiction over whether a pretrial motion was handled in an erroneous fashion.
But I guess, and I apologize, Your Honor, if I'm just repeating myself, but my point is that
you just think that's waived.
That argument was first presented to anybody 14 days plus.
I've got that.
Okay.
Now, let's focus on whether it's reasonable for there to be a requirement because of the Sixth Amendment issues that are involved here to say a pro se motion has been filed. Once that's done, a district court must do something on the record to show the disposal of that motion, even if it's to have a hearing where the defendant's there and the defendant's lawyer's there. And we don't even know if that happened or not, but I'm just saying, what's wrong, what's unreasonable about saying that once that paper motion gets filed, something has to happen definitively that can then be reviewed on appeal for purposes of protecting defendants' Sixth Amendment rights?
Well, I think that it was.
But we don't, all we know is that minute sheet says it's gone. And there's any number of opportunity or of options about how that thing got filed. That's my problem. It could have just been a judge who decided he didn't want to hear it that day.
Right.
It could just be a lawyer that didn't want to have someone come in and complain about him. So,
Right. So
that's accepted somehow.
My way of thinking about this, Your Honor, is we're sure of two things. One, that the motion was filed. Two, something happened. And the third thing that I'm aware of is that this court assumes that it happened correctly unless it is affirmatively indicated that the district court erred. That is opposing counsel's burden, to bring to you affirmative indication in some form that the district court erred.
How do you prove a negative? I mean, the record before us, I think, does establish there was no hearing with the defendant present. We have both the minute sheet that doesn't show his appearance, and we have the defendant saying, "I didn't go to a hearing."
So you're willing.
What more do we need?
Well, you're willing to use the minute sheet to demonstrate what didn't happen, but not what did happen. That's the problem I would have with that scenario.
I think maybe look at it this way. We have affirmative statement by the defendant. I was not at a hearing, and the minute sheet does not contradict that.
But if you're willing to interpret the convicted murderer defendant's comments to mean one thing, I think we ought to at least be willing to interpret Mr. Manx language as well, which is, "This is news to me."
Which then suggests that Mr. Mink didn't know about this withdrawal as well?
Or it suggests that he was aware of everyone was aware of the motion to withdraw. It was done with consent, and it's news to me that he's complaining about it again. That makes the most sense. We know this happened.
It still does not answer the fact that the district court did not fulfill the district court's duty to make inquiry of the defendant.
Well, we don't.
We have nothing that suggests that's. The only thing in the record is the defendant's statement, and we have nothing to contradict the defendant's statement.
Except for the minute sheet that indicates it was withdrawn.
No, the minute sheet does not contradict his statement that he was not present and no one asked him. The district court did not ask him a question.
Mr. Manx's statement of "this is news to me" can be interpreted as contradicting that.
Don't we have one more duty in there that we skipped here? When a court enters a ruling, doesn't it have an affirmative duty to make findings of fact, conclusions of law? And so the check mark didn't fulfill that here because we don't know who was present, the withdrawal by whom, and that's why we require findings. Granted, defense counsel, we've placed a concurrent duty to ask for the findings on appeal, but there was that duty at the hearing.
I can't argue against the fact that this court has held in certain circumstances that the district court needs to make a ruling that can be reviewed. However, I also, as Your Honor indicates, there is the concurrent obligation on counsel to, if that ruling doesn't seem to be reviewable to you, you have a duty to ask the judge to flesh it out more, or else it's waived.
That duty's there whether there's an appeal or not.
Yes.
I mean, there's a duty to make findings whether it's appealed or not.
That's correct. Yeah. I just can't, in this case, just can't get past the fact again that the first time we hear about the complaint is 14 days plus the verdict, and opposing counsel has a duty to affirmatively show to you something happened, something went wrong, and I don't think that's taken place in this case.
Could you, the structure in which this takes place, this is a pre-trial, I think pre-preliminary hearing request by the defendant. how does that get heard in Sedgwick County? Is it set on some sort of like motion docket? Because as I look at this, 3 different judges handled Mr. Brown's case. We have, I think, one judge handling this particular motion, another judge doing the preliminary hearing, and then a trial judge doing the trial and the sentencing.
I understood it.
And how does that work?
I understood it was Judge Waller, but I believe one of the judges.
Which one? But how does it? So there's a.
I think that in my recollection of what would happen is the pro se motion would have been processed. Since this person was in a trial proceeding, it would have been set before a judge, and then that's what this is, and then whatever happened.
Okay. But then the sentencing judge who's looking back on this, or even the preliminary hearing, just sees
that's
withdrawn motion.
It's a totally different judge. My understanding is whichever judge it is that's on this pro se motion is not the same judge at sentencing.
Right.
That's correct.
In our discussion, we kind of have glossed over the fact that there was at least what appears to be an oral pro se motion at sentencing hearing. And do you believe a proper inquiry was made of the potential conflict at that sentencing hearing?
The court was without jurisdiction to make that inquiry.
To make an inquiry of when a defendant stands in front of you at sentencing?
It was outside of 14 days.
I would agree there was no jurisdiction to consider it as a motion for new trial. But why wasn't it just an obvious oral motion?
Then the complaint would be, I want a new sentencing.
I understand we've got that issue of relief again, as to remedy, potentially. But I'm just asking you, was there a proper inquiry at that point when the issue was renewed before sentencing?
To my knowledge, it was it was resolved in a summary manner at that point.
You would agree that the judge's inquiry was not sufficient?
I would agree that if the court had jurisdiction over it, that then there would be an issue of whether it was satisfactory or not. But as I indicated, the court was without jurisdiction to review that motion. Pro se. And again, and I think it was Justice Johnson indicated, there's a procedure. Surely we would have some entitlement to some sort of notice that a motion is going to be heard, or of this nature. So it's difficult in a number of levels, and the way that it came up, and the fact that it was oral.
So can we assume there was error probably at 2 points in this proceeding? The question now that you would raise is whether we have any ability to provide any remedy to the defendant because of the procedural manner in which the errors are raised?
Well, I would not concede there was error at any portion of this case, I guess is the way to say it.
But
more so there would have been at the sentencing hearing, because I don't know what happened here exactly. I do know what happened at the sentencing hearing because I can read it. But it could have been an error that was not, an error that doesn't matter, in that the court didn't have jurisdiction. And if that court didn't have jurisdiction, this court doesn't have jurisdiction to review it. I think that would be my answer.
Also, we spent a lot of time firing questions at you. Would you like about 30 seconds to wrap up, or do you think you've made your points?
I hope I made my point. I'd open up to any other questions on this issue or any other issues if the court has any questions.
I do think I want to go back to my earlier question, and I understand you don't think we have jurisdiction, so let's set that answer aside. Is there anything unreasonable that what would come out of this case is to say that when a pro se motion has been filed, the district court has an obligation to generate a record that shows how that pro se motion to withdraw has been handled?
Are we in general, or a pro se motion that touches on a conflict in the Sixth Amendment? Is there anything unreasonable about that? I wouldn't think there would be anything unreasonable. In fact, I think Justice Johnson has indicated that duty already exists. I'm talking, I know this court makes, I know how it works at this point. I know this court makes rulings that are going to be applied in the future and apply to cases other than this one, but I also know that this court on a number of occasions has limited the ruling to the facts of the case. And that is what I'm asking in this case. We don't know. It's not my fault. We have a rule about who's responsible, and if that duty wasn't fulfilled, then that's where the inquiry is. We don't assume error. It must affirmatively appear. That burden is opposing counsel.
I still don't understand how that helps you, because the record establishes that the defendant was not present for a hearing and no inquiry was made of the defendant.
I don't know that that's what it is necessarily establishes, and
we have the defendant's statement, and there is
Okay,
nothing in the
all right.
record to contradict it.
well, other than the statement of counsel, this is news to me. Would indicate that everything that person just said, I don't understand what they're talking about. I mean, this is news to me. Could indicate you're now claiming you weren't present at a hearing. That's news to me. That's the problem with speculation.
I need to take that, and I agree with you, that's the problem with speculation, but I think you're taking that comment further out of context than it needs to be, because as I read the transcript, he's saying, you know, we had a meeting just a couple of days ago or a week ago where we talked about the pre-sentence hearing investigation, and he's saying, now this is news to me. So he's just saying this issue hadn't come up during that earlier discussion. I think that's a fair reading. I don't think it means to say that there's some denial about what the defendant had said earlier, a couple of exchanges ago.
Well,
So I mean, the problem is we don't know. And I think, and you say you get the benefit of that, and I don't think that's an unfair position. You want us to, but the choice is we either remand and look at the issue now, or we wait for it to come up as a 1507.
and there's nothing wrong with letting this process work.
But I'm saying, I think those are the two choices.
Or the third choice, which I don't think is, that it was actually requested in the brief, which I don't think, as I understand it, if the relief can be changed at the podium, then I guess the relief can be abandoned at the podium. So as I understand it on the table today, is no longer a request for relief in the form of a new trial. So yes, in that respect, I guess the options have been limited to those two. And I don't, as a representative of the state of Kansas, I guess there's no reason why the process can't work.
Could you summarize for us the textbook, law book, A+ solution to how this motion should have been handled? The pro se motion. The pro se motion.
The pro se motion, I suppose if the textbook, number one primo way to do this would have been, even if opposing counsel comes in and I'm sorry, opposing counsel for defendant comes in and says, well, he's waiving that, I met with him, then I guess the textbook, number one way would be, well, let's get that on the record.
There's no need for the defendant to be present for that.
Well, that's what I mean by get it on the record. I'm sorry, have him come and have him say it. But we don't. My experience has been that defense counsel and the defendant don't really want the defendant to be on the record saying things because you don't know what's going to be said. So we try to limit the contact of the defendant themselves on the record, because they could say something that would torpedo their case as well. You know, I've seen this before. Well, I admit I did it, but you never know what they're going to say. And there's also a competing interest, I would think, that the district court judge would have, and that the counsel would have, is I don't know how far I want you to go into my privileged communications with the defendant. I don't know what is he going to divulge in addition to directly answering the questions that are asked? How far is the judge going to go? Is the judge going to cross some boundary by asking a question that doesn't necessarily need to be resolved today? Ask it in the wrong way? These are all competing interests. I think that are legitimate competing interests. So, I don't dispute that this isn't the textbook way to handle this, but it was handled, And so now the question is, what do we do? And I think we let the process work.
Right. Thank you.
Thank
Any
you.
further questions? Thank you, counsel. You reserve 3 minutes for rebuttal.
Thank you. I think the court's questions to my opposing counsel pretty much covered everything I was planning on saying in rebuttal, so.
Let me get it straight here. Your client waited until allocution to raise this.
Yes.
There wasn't any other opportunity prior to, this is your opportunity to say anything you want in mitigation of sentence, and this is what he raises?
That's correct. I would argue that this was his invitation from the court to address it directly. So, yes, in his mind, that was probably his only opportunity.
Okay.
And you did not ask for a Van Cleve hearing?
I did not.
And should we hold that against you in this context?
I don't think so. I know our office general policy is to only request those in very limited circumstances, and I didn't want to prevent my client from raising other IAC claims against his attorney later on that might have been barred.
You're not alleging ineffective assistance here.
Right.
You're just saying you didn't get a hearing on something you should have had a hearing on.
Well, I'm not sure that a Van Cleve hearing would have been appropriate.
Yeah, Van Cleve is to determine ineffective assistance and whether there's prejudice.
And this was more the district court's failure to inquire and the proper procedure that should have happened.
And you don't think the attorney has an obligation to make sure that the district court follows proper procedures in handling motions filed, even a pro se motion filed by your client?
That could have been a subcategory of that hearing, I suppose. But I think that the facts of this particular case are so confusing that I'm not sure would have been born out of that hearing from him, the attorney. He seemed to have no knowledge of anything based on his
what's wrong with the state's argument that we should consider this issue waived or beyond our jurisdiction and then let it get fleshed out through the hearing process of a 1507?
I would argue that that is inappropriate. Of course, Mr. Brown can raise a 1507 alleging ineffective assistance of counsel later on, but I'm arguing that the district court failed in its duty to inquire and to assure Mr. Brown his Sixth Amendment right to counsel for the trial.
But does that automatically entitle Mr. Brown to a reversal of his conviction?
I suppose not necessarily, but that the duty is still there for the district court to inquire.
And at this point, is that our standard? I mean, in order for us to take action on this appeal, must you have established a reversible grounds?
No, I don't think so. I don't think State v. Van required that. I think it's just the lack of the district court's fulfillment of its duties is enough for this court to remand.
And why do you believe that, given the request for remedy in your brief?
I guess when I asked for reversal in the brief, I was couching that in terms of the district court's failure to ensure that Mr. Brown had his Sixth Amendment right to counsel, and perhaps that was a mistake. But I don't think that inhibits your ability to remedy the situation.
Mr. Plyvan.
Again, my initial question was, this occurred at allocution. So you're suggesting, here we have a sentencing, gone through the pre-sentence report, heard from the state, heard from defense counsel. Apparently victims testified or offered a statement at this. I'm not sure if there were people for Mr. Brown offering statements. And then your client has an opportunity to say something in allocution, in mitigation, or whatever he would like to state. And then this court is supposed to stop everything, and do what at that point? What is supposed to happen here? This is kind of the peak of the sentencing, and then the court's going to pronounce sentence. It just stops because he raises this question.
Well, I guess my complaint is not so much with what the sentencing court did in response to that statement from Mr. Brown.
And maybe that was, but what is supposed to happen at that point? What should happen when he raises this complaint? It just
Yeah.
stops, sentence not imposed, or what happens? Is that a legal reason why sentence should not be imposed?
No, and I don't think I argued it.
Maybe it is. I don't know.
Why wouldn't it be illegal?
I'm not saying maybe it
Right.
is, but what? I'm just trying to think functionally what's supposed to happen.
It's a tough spot for the district court at that point. I agree.
But are you raising an issue about that being a second oral motion to, for new counsel?
I did not raise it like that in my brief. Basically that statement from the defendant alerted me to the earlier transgressions of the.
Well, and that's what he complains about.
Right.
And he said, I wrote this down. First thing I would like to say, I wrote this down. He says, all a matter of record, and he goes through what happened. But when he tries to explain, the court says, don't speak. Do not speak. So, I mean, if it's not only no inquiry, it's a preclude from making that any further statement about that.
That's correct.
I'd like
Well,
to.
I think it goes further than that. I mean, doesn't the judge advocate for the state's position?
Yes. He basically scolds the defendant and asserts his own opinion of the defense attorney in that position without asking the defendant what the problems were, basically.
What precisely is the relief you're seeking today? I've heard several options and versions.
Right. Well, of course, our office would always ask for a reversal, but if the court doesn't want to extend it that far, a remand for hearing would at least be appropriate.
Did you ever ask for that in your brief?
No, I did not, Your Honor.
Any further presentation?
No, Your Honor.
Any more questions? Thank you, counsel.
Thanks.
Thank you both for your arguments this morning. Court will take this matter under advisement.